Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our two-weekly community conference call. Well, not two-weekly, actually, we do it weekly. But 1 week we do it on LinkedIn, and 1 week on this phone number, which is 202-800-8394. When you logged in, you heard certain disclaimers and certain cautionary statements. All of those apply. So I'm not going to repeat them again. Let's begin our conference call. What I'll do is, somewhere along the line, when I feel I have enough people in the call, I will lock the conference because I want to make sure that people who are here get their questions answered. So you'll also notice that we don't advertise these calls too much because I want to be able to attend to people rather than, just give everybody 5 seconds. So therefore, in about 5 or 10 minutes, I think I'll close the conference because we already have enough people. Maybe another 5-10 minutes, 5 minutes maybe. With that, I also remind everyone, the way I'll do this is, a couple of weeks ago when the team called me and said, okay, we have enough questions, I went over the questions. I marked certain questions posted in our forums as frequently asked questions. First, I will deal with the frequently asked questions because that's something common to everyone. And after every frequently asked question, I'll ask you if you have a follow-up question. That way we can cover all aspects and variables with that question. After I'm done answering the frequently asked questions, then I'll go into the other posted questions. Again, I'll ask for follow-ups. And if you have one, feel free to ask, but please don't ask any new questions. In these calls, I make sure that everybody who's here gets their questions answered. So you don't have to worry about not being able to do that. You might have to wait a little bit. But I think the information should be, if not entertaining, at least enlightening for most people. So stay on and I'll get to everybody's questions. I'm going to lock the conference. I don't like doing that so early, but we already have enough people. So hold on 1 second. I really hate to do this. Let's wait another couple of minutes, okay? So the first frequently asked question is about international managers EB1C changing jobs under AC21 portability after 180 days. So generically, you know what portability is. My 485 has been pending 180 days and I have an I-140 approval. I can take a same or similar job anywhere in the country with any kind of employer, even take a promotion as long as the jobs are same or similar in nature. So I can't go from being a software developer to a historian, but I can go from being a software developer to a delivery manager or maybe even a CTO, okay? So, which is great. So that's called portability. And what portability does is it allows you to not have to file a green card again. So you just take the entire green card which is pending over to a new employer. Okay. So that facility is, oh my God, we have a lot of people. I'm going to lock the conference. Sorry, guys. Okay.
The conference is now locked.
Yeah, I didn't realize how many people we had already. So now I'll make sure everybody who's here, their questions get answered. So international managers are also allowed to do portability. Now, what is an international manager? IBM India sends somebody to IBM USA who's a managerial or executive level employee. That's what it is, intra-company transferring. Now, after 180 days, I-140 is approved. I want to change my job to Microsoft. Can I do that? The answer is yes, as long as the jobs are same or similar. Well, the question which is often asked is, well, this is a different company. It's not a part of the same group of companies. Well, that's how it is. That's what is portability. If you stayed in the same group of companies, you won't even need portability, right? So here's the question. I'm on L1A, approved EADAP, 180 days over. Can I switch employers? Yes. How will USCIS match my job duties? Same or similar? Your lawyers will help you in that. How can I show that I have international manager experience with the new employer? That's not required. So when you first got the L1A or the EB1C, you had to prove that you had the right kind of experience with the related company. Now that you are in AC-21 portability, you do not have to do that. So this is very liberating actually. AC-21 portability is one of the better provisions under immigration law. Okay, I hope this helps. Anyone has any follow-up question on what I just discussed? Please press *5. Do not ask new questions at this time, just a follow-up question. Press *5. Okay, I don't have any questions, follow-ups, yep. Let's go on to the next frequently asked question. This is also very important. So this is on H-1B 60 days grace period. H-1B transfer, impact of switching to B-1, B-2, and family visa validity. So I think there are two questions here. There's another question asked by somebody else about status gap and transitioning back to H-1B, starting work again. Some of this I have covered already in an article I wrote, I think 2 weeks ago in the Economic Times, which was about switching to B1, B2 and then switching back to H1B. That is perfectly okay to do so. So if you Google my name, Rajiv spelled with an I, Rajiv S. Khanna, Economic Times, you'll come to the articles. Read through that. I have some other stuff there which you might like also. National interest waiver and F1, all those kind of things. Okay, so let's begin with the frequently asked questions on H-1B grace period. Excuse me. If I apply for a B1, B2 on the 59th day of my grace period, it is approved within 2 weeks. Can my new employer still file an H-1B transfer? No. Because then you are on B1, B2. You are not on H-1B. If the B1, B2 is approved, obviously, then the H-1B is gone. Okay. Specifically, I'm concerned about the impact of my status change from H1 to B1 and then back again to H1B. Yeah, it's because of you folks that I wrote that article, simply because so many people were concerned about these switches. This is perfectly okay. There's no big deal here. My family members hold a valid US visa stamping until March 27 with the previous employer 797. Can they enter the US using this visa? Not unless you maintain H-1B status. Unless you come back to H-1B status, they should not try to enter using your H-4 visa. Okay. Anyone has a question, press *5. Follow up only, please. Okay, let's go on to the next part of the frequently asked questions. Oh, what did I just do? 1 second. International managers. Okay. H-1B 60 days grace period. Okay. Hello, based on our conversation regarding converting from H1 to B2 through a paid appointment. Oh yeah, okay, so this is somebody who did a consultation. I proceeded with filing the I-539. As you mentioned, I got my approval for B2, but now I have another query, okay. Background, laid off and applied 539 online on March 28th. 60-day grace period ending on March 30th. So a couple of days before he applied. Received approval on May 3rd, but I-94 attached mentions the date of B2 as May 22nd to September 28th and not to March 29th to September 28th as requested. So first of all, it is usual for the government to begin your B1, B2 on the date of the B1, B2 approval, not on the date you applied. So you received approval on May 23rd. They started your B1, B2 from May 22nd. And instead of giving you 6 months from there, they gave you only till September 28th, which is okay. It's not the end of the world. And don't worry about that period which they have kind of gobbled up. And you worry that was I out of status? The answer is no. And that is your worry. What was my status from March 29th, which is when he applied, to May 21st, which is when the approval begins? So don't worry about it. This is a common issue. You are perfectly fine. This question may sound lame. No, there's no such thing. I did not receive an appointment for biometrics. So is biometrics exempt? You know what? I have no idea. Our team would know. I hardly get into the tickets. I don't really know exactly if they are doing biometrics. Are they using old biometrics? No idea. Sorry. Now when I get a job and convert to H-1B, I do not have to leave the US. And my case can be approved within the US. That is correct. Yes, sir. Is my understanding correct that I can start working only after my H-1B is approved? Yes, absolutely. Not after USCIS receives the petition. That holds true only if your H-1B is received within the 60-day grace period. Okay. Star 5. If you have a follow-up question, press star 5, please. All right. Let's see if there is any other frequently asked questions. Okay, I don't see any other frequently asked questions. Now let's go to the routine questions. After these, we'll start with the new questions. This is question number 4, OPT filing, Day 1 CPT transfers, H-1B concerns, and switching from IT to civil engineering. Okay. When is a good time to file for the OPT as per your experience for someone who graduates in Jan or maybe August? So there are 3 different variables, and I don't remember them all. I could mess them up. First, you have to apply within a certain number of days before or after graduation. First period. Second period is your DSO will recommend your approval, and you have 30 days within which to file. And the third period you have to worry about is when do I want my start date? And usually your DSOs can guide you through those things. Okay. Is it good practice to complete a semester on an F1 and transfer to Day 1 CPT college? I feel like colleges are not so helpful, and we need to learn the skills all by myself. So here is what I want you to do. I've mentioned this before. Go to the website. You can just Google one word, studyinthestates.gov. Study in the States. The whole URL is actually DHS, Department of Homeland Security, dhs.studyinthestates, one word, studyinthestates.gov. This is a very good website. This is maintained by the Department of Homeland Security. It tells you not only from the student's angle, but from the DSO angle what they are supposed to do. So you can actually see the service screens, what they are supposed to fill out. Okay, good website. Is there any hidden advantage if we do it during the process of H-1B filing or in the future? Not sure what you're asking me. If you're here, press star 5. Okay, you're not here. So I'm not sure what you're asking me, but there are those 3 variable times that I talked about. You should discuss them with your DSO. Also, if there's an RFE during the OPT, how do we maneuver by substantial evidence? Well, these RFEs are rare. They happen, but they are usually because some mistake was made while filling out the paperwork. As long as the most important thing is to file within the deadlines and to comply with those 3 variables that I mentioned. Okay. Another question is, I have done engineering and enrolled in a master's in IT. I'm considering dropping the course and taking a master's in civil engineering. So any fruitful cases of civil engineering getting O1 or EB1 as the market has fewer of them? No, we've done civil engineering, both O1s and EB1As. In fact, one of my earliest cases when EB1s first came was a civil engineer. But I don't think having a master's is necessarily that much of an advantage, but it could be an advantage for a national interest waiver. Is there any advantage or easier lottery pick for a professional licensed civil engineer? Not at all. Is there an H-1B score for engineer? No, no such thing. All professionals, whether they are history majors, geology majors, or neuroscience majors, or technology majors, they all enjoy the same level of respect or disrespect from the USCIS. Okay. Star 5, if you have a follow-up question on what I talked about, press star 5. I just want to make sure you can hear me 1 second.
The conference is now in conversation mode.
Can you guys all hear me?
Yes, we can.
Okay, excellent. Thank you. Thank you.
The
Yeah.
conference is now in presentation mode.
Okay, so now question number 5. Switching employers with approved I-129 after STEM OPT options for returning to the US from India. I left the US after my STEM OPT ended, transferred internally to India location. H-1B was picked last year's August, got the I-129 approval, couldn't get the visa stamped. The company didn't want me to transfer back. Can I switch to another company in the US with approved I-129 even though my H-1B isn't activated? So the answer is we don't know. The government has never made this clear. If you had a visa stamp, at least chances are better. Without a visa stamp, it's difficult to say you want to try. You certainly can. You have nothing to lose. At the most, they will deny it. It's not the end of the world. So you can try. Star 5, if you have a follow-up question, press star 5. Question number 6, applying for F2 visa after H-1B layoff, best consulate joint application entry requirements. I was laid off H-1B September 23, changed my status to B2, which will end soon. I just applied for change to F2 status. I want to ask about applying for F2 visa at US Embassy while this is still pending. Okay. I'm considering going to Canada to apply for F2 visa since my husband's home country is Serbia and my home country is Vietnam. Is it advisable to apply in Canada or is it better to apply in Serbia or Vietnam? Well, there's no bar on applying from a third country. And since you came to this country on a visa, it's not like you are unknown to the government as far as visas are concerned. So you can apply in any country. But the third country like Canada can say, look, you have to apply where you are a permanent resident. So whether that's Vietnam or Serbia, that's where you should go. But you can certainly try. Should I apply separately or should I apply with my husband? I don't think that matters. My husband has been studying in the US for 4 years. He'll apply to renew his visa and add me in his application. However, if I choose to apply in Canada, he'll have to go with me if we apply together. I read somewhere that F1 visa holder needs to accompany F2 visa. No, that's not true. There is no requirement that the F1 visa holder go with you. Yeah, there's no such requirement, ma'am. Okay. Star 5, if you have a follow-up question, press star 5. Okay. Question number 7, Naini. Day 1 CPT to H1B, employer change before October 1st and RFE avoidance. I'm on day 1 CPT. Is it possible to change the employer before October 1st, right after getting the H1B approval? I would wait a couple of paychecks just to avoid any problems. Okay. Then next question is, will my spouse and I be interviewed together or separately for the green card? So if you're an employment-based case, they usually take you together. It looks like you are. So you pretty much they talk to both of you at the same time. You are called, they might give you separate time slots, but usually they are right back to back and they'll probably take you in at the same time. Okay. Star 5, if you have a follow-up question, press star 5. Question number 9, travel to Canada with an expired H-1B stamp and valid 797. I'm on H-1B, stamp expires this year in September from company A. I have an approved 797 till 25 from current company. I-94 is valid till September only. I'm planning to travel to Canada on tourist visa in December 24. Oh, I think you are here. I think you just talked to me. I can travel to Canada for 39. Yeah, we just talked. So you're already covered. Can I travel to Canada on tourist visa and come back to the US on expired H-1B? Sure. Sure. No gotchas. As long as you've been maintaining status, you can travel on the expired H-1B stamp and the valid 797. That's what AVR is. Any follow-up questions? Press star 5. Okay. This is question number 10, H-1B visa using Upwork as a client, no income received. On H-1B visa, can we get a project done on Upwork and pay for that as a client, not receiving any money? I think so. I mean, you're not getting money, you're paying money. I don't see any problem with that. Press star 5 if you have a follow-up question. Press star 5. Oh, I'm so sorry. Asylum, I don't know anything about Asylum. Asylum is an option after unsuccessful H-1B lottery attempt. Sorry. You don't want my advice on Asylum. Okay, that covers all the posted questions. All right, folks. Anyone has any question, press star 5. Let's see how many people are there. So far I have 4 questions. Now that's easy. Okay, no, now I have 8. Okay. Anybody else has a question? Press your put up your hand, please. Press star 5 if you have a question. 9 people. So 9 people have their hands up. 10 people. Okay, that's a nice even number. Let's go with whoever logged in first, which is Illinois, area code 630. Let me find you. Show queue. I'm looking for 630. And here is 630. Area code 630, Illinois. Go ahead, please.
Yeah. So this is Gautam again. So one quick question I forgot to ask regarding that B2 from B2 to H1. So within 60 days grace period, I heard you mentioned there is no issue. After 60 days grace period, if B2 is still pending and I got my H1 approval, in that case, do I need to go out of country or not at all required?
So the situation is B1, B2 is pending. H1B is approved with a new I-94. Just immediately revoke.
After 60 days.
After 60 days. Immediately withdraw your B1, B2.
So that I can with B1,
yeah,
B2
because
or?
you filed the B1, B2, not your employer, right? So you get to withdraw it.
Correct.
Yeah, do it in consultation with your lawyers, but that's what you should be doing. Okay,
but there is no need to go out of country and come back, right?
No, there is no need.
Okay. And for the new H1B, because I'm putting from B2 to H1, so I need to wait for the approval. Based on receipt number, I won't be able to work, right?
If outside, I have already answered that question 3 times. As long as it is, if it is outside the 60-day grace period, you have no choice but to wait for the approval. If the application is received by the USCIS within 60 days, you can start working. Otherwise, no.
Okay, got it.
All right. Good luck.
Yep. Thank you, sir.
You're welcome.
Thanks. Bye.
You're welcome. Area code 405, I believe that's Oklahoma.
Hi, Rajiv. Can you hear me?
I can. Go ahead, please.
Yes. So my question is, currently I'm on STEM OPT and working for 2 employers as a full-time. And my H1 got selected for this year. And I'm currently filing with both of them. And both of them are starting from October 1st. So what could be the best case for me to do? Because I believe I should quit one employer. If I need to quit, what could be my last day of working with second employer?
Yeah, so it has to be September 30th. Okay. And what can also be done is, if both employers are okay with it, you can also do, one of the employers can file a concurrent H1B for you. Okay.
That means I need to inform them and let them know that I'm working for this as my primary.
Yeah.
And I need to ask them, like, with the primary H1B, you need to employ me back. Is that what?
Yeah, you can file a concurrent H1B. Let your lawyers worry about the details. But any one of the 2 employers can become a concurrent employer. Okay?
Okay, awesome. Thank you so much, Rajiv.
You're welcome. Good luck. Okay. The next one is, I think it's Colorado. 720, area code 720. I can hear you, 720. Did I not? Hold on, let me double check. Oh no, I don't know where you are. I think we lost you. Okay, let me just make sure. 1 second. What happened? I think there's another Colorado here. Let me try. Area code 720. Go ahead, please. Colorado.
Rajiv, can you hear me?
Yeah. Did you get dropped out?
No. I think raised my hand, but maybe you muted someone else.
Oh, no. I think it was you, 720.
Yeah,
Okay. But go ahead. How can I
I
help?
can hear you.
Yeah. Go ahead, please.
Yeah. My question is, that if you have a Canada business visa, can you use it for like tourist purpose? Because the visa says business / tourist. So,
You're asking me about visas on the Canadian side, right?
Yeah.
Yeah, I have no idea because we practice on the US side.
Okay.
So
Okay.
I wouldn't know what that is.
So, thank you. A follow-up question on the AVR. So, if primary applicant application is approved and dependent application 5539 is still waiting, can they do the AVR based on the primary applicant approval?
No, they cannot. They have to
wait for their approval.
Yep, they have to get their own approval. Okay.
All right. Thank you.
You're welcome. Okay, next one is, I think it's California. Hold on 1 second. Let's see. It's, California. 619. Go ahead, please. 619.
Yeah. Hello. Yeah. Hello, Rajivji.
Hello, ma'am.
I had a question regarding transfer from STEM OPT to Day 1 CPT.
Mm-hmm.
So the question that I had is, if my STEM OPT EAD end date is June end, but if I end my STEM OPT early, like 2-3 days early, because service transfer to the new school might take some time. In that situation, basically I understand that on I-983 final STEM OPT evaluation, the end date should be the day on which the STEM OPT ended, right? Not the actual STEM OPT EAD end date, correct?
Okay, so I am a little lost in your questions. 983 is coextensive with your actual work, right? So as long as you are working,
yes.
That covers.
Yes.
Okay. So as far as the STEM OPT itself is concerned, it is coextensive with your EAD. As long as you have EAD, you have your STEM OPT, correct?
Yes.
Okay. So now what is the question? Those two things are understood. So what is the question?
So if the STEM, if basically the work authorization is ending 2-3 days before the STEM OPT end date, in that case, I-983 form, which is the final evaluation, the end date should be the day on which the work ended, right?
Whatever the actual date is, that's what it should be, yes. That's what it always should be. All right.
And another question that I had was during STEM OPT to CPT transfer, I understand that employment gap should be unpaid. But in case if the previous benefits are accrued, and because of that, if somebody is getting paid during that time, is that a valid condition, or one has to be on unpaid leave during that time?
So I am definitely quite confused by that question, but let me see if I can paraphrase it and you can tell me if I've understood it. The question is, can my benefits be paid even though I don't have work authorization, right? That's the question.
Yes, I mean what I'm trying to ask is, during STEM OPT to CPT transfer, there has to be an employment gap because the work authorization is getting transferred to new visa. So during that time, ideally, the person should not get paid. But if because the employment benefits such as a leave are accrued, because of which I would get paid even though I'm not working during that time.
Yeah, hold on. Let me back you up. I understand. So let's say I worked from June to August. In August, my work authorization expired. But in September, I got paid for something I had done in June. Is that legal? Right? That's the question. And the answer is absolutely. Because the work was performed when you were duly authorized. The leave was earned when you were duly authorized. Okay. So you can get that money even though your work authorization is no longer valid for that job. Okay?
Okay, got it.
Good luck, ma'am.
Thank you for answering the question.
You're welcome, ma'am. Bye-bye. Okay, let's go on to 347 area code, which is, hold on one second, where are you? New York, okay. 347, New York, go ahead, please.
Good afternoon, Rajiv.
Good afternoon, sir.
This is a question on behalf of one of my R1 friends, and he has some language barriers, so I'm asking a question on his behalf.
No problem.
Thank you, sir. He was on R1 visa, which the 5 years was done, and he has the I-360 approved, and now he has filed his I-485 adjustment of status, and he's waiting for the approval. He got an RFE, and he's waiting for the approval. He says it can be any time. So the question is, how would his wife is in India? Is it possible? How would be able to get his wife here?
I cannot think of any way he can do that. Because his R has expired. He's here because his adjustment of status is pending. So what he should do is, he should, as soon as his green card is approved, he should file for her following to join. It's going to take a few months, but that's the only option I see. I mean, he can also apply simultaneously as the spouse of a green card holder, and whichever comes first, he takes that. Okay. So
it's a follow to join or the I-130.
They can do both, right? Because following to join is taking benefit of the employment-based category, and I-130, which is through spouse of a green card holder, because he has become a green card holder. He can also apply through that category. So whichever comes first, she gets that. Okay?
So is this follow to join, is it applicable for the R1 category?
Yeah. So following to join is based upon his employment-based case, whereas the I-130 green card spouse is based upon his family-based case.
Okay.
Okay.
Thank you very much, Rajiv.
You're welcome, sir. Good luck. Area code 682, Texas. Texas, go ahead. I can hear you. Texas.
Hi, Rajiv. I am currently on STEM OPT, and I haven't received my EAD card so far, and my last working day is on 6/19. Sorry, I'm on OPT, and I haven't received my STEM OPT EAD card. So my
hold on. STEM OPT EAD. Oh, okay. Somehow my mind got stuck with curricular practical training. Okay. So you have not received your card. When does your current OPT expire, sir?
6/19, like 19th.
June 19th. But then after that, you have a 180-day grace period that you can continue working, right?
Yeah.
So no issues, right?
So like, do I need to make any sort of documentation or any updates on any website?
Yeah, let your employer worry about that. You don't have to do anything. The employer is required to have proper work authorization recorded on the I-9. And the I-9 instructions should be known to the HR people. They should know what to do. You are authorized to work. As far as you are concerned, you are not breaking any law by continuing to work without updating anything. Okay?
Okay. And this is also related with one of the call that we had about the H-1B thing with a cap exempt employer. So earlier they told me, like, once I receive my STEM EAD approval or, card, then they can process my H1 thing. But now their intention are kind of a little different. So can I ask them to at least file my I-140 so I have a priority date in hand?
Yeah, that would be great if they do that. Sure. Absolutely.
Like, is that a doable thing from their end if they are even not filing a H1B?
Yeah, they can. Yeah, you don't have to be actually employed with the employer before they start your green card. No problem.
Okay, and I know that on your portal you have a fees section where you have fees for all of these, but just wanted to know like how much does it cost for a non-profit company to file I-140 and H1B?
Oh, I cannot remember numbers. You don't want me to tell you that. So, okay, hold on.
Is it like more than 1,000? Because I'm not sure like if they are
it's
more than 1,000.
Probably more than 1,000. So what you have to do is USCIS has a filing fee calculator. Okay, they have a little widget. You can actually go and answer some questions. It will give you the filing fees. Okay.
Okay.
Good luck.
Thank you.
You're welcome. We have after this one, which is Canada. I have 3 more people only, so we are good. We are good on time. Everything is going well. So Canada, area code 672. Go ahead, please. Canada.
Hi, Rajiv, sir. This is Abhishek. Yeah. Can you hear me?
Yeah, I can.
Can you hear me?
Yes, sir, I can.
Okay. Yeah. Hi, Rajiv, sir. This is Abhishek. Yeah. So I completed my master's from California in 2020. And after that, I used all my CPT and OPT. Okay. And I'm not picked up in the H1B. So that's why I left US and moved to Canada around 7 months prior to the expiry date of my ED card. Okay. And I was working remotely for my US employer until my ED expired.
Okay.
And now I'm in India. So now I want to go back to US for my PhD. Okay. So the thing is that my previous employer already filed my I-140 and it is already approved. So my question is, if I even offer an admission from the US universities, and now if I attend the US visa consulate in India for the F1, so would I face any problem as I have the I-140 already approved?
So if you had asked me this question a few years back, I could have had some doubts, but it's become relatively common for employment-based cases to be I-140 to be approved and people getting their student visa. Now, can I predict the outcome of your application? Absolutely not. Is it a complete and immediate disaster because you have an I-140 approved? I don't think so. So bottom line, it's worth a shot. Go ahead and give it a try. Okay.
Okay, so if I have all the valid, proof that, once my PhD is done, I will come back to India. Like, what is the expected answer those people expect from us?
Always the truth. Never try to make things up. Okay. In fact, when you are going back as a PhD student, if you get a really great job and if the law allows you, you would like to stay. Why not? I mean, that's the truth. But you would not break the law. That's equally the truth. So,
Yeah, I did not break. Yeah, yes. I even left the US 7 months prior to my
so you should.
Date
Yeah, you can bring that. You can bring that up. Look at my record. I left early. Okay.
Yeah. And also I did not take the day one CPT option.
Yeah.
So I had the pure intention to come like leave US.
Right.
That's why I'm again asking for the PhD for the intention of the study only.
Yeah.
And another thing, suppose I'm applying for the B1, B2. So I'm going to the US in the B1, B2 visa. And after that, what is the time frame after which I can convert it from B1, B2 to F1 visa?
Well, you should be careful because normally there's a 90-day period, of course. But You should not enter USA on a B1, B2 if it is your intention to convert to F1. There are, people do it. It's not illegal by itself, but it's something to be avoided. Might as well come on an F1. Okay, that's what I would recommend. So I have to take my next call. Okay.
Okay.
Good luck.
Okay. Thank you. Thanks.
You're
so
welcome.
much, sir.
All right, sir. Bye-bye. Let's see. Area code 980, North Carolina. North Carolina, go ahead, please.
Hey, hi. Hello.
Hello.
I just had one question about the compelling circumstances EAD. Actually, I had two. I'll start with this.
Okay.
So I have my I-140 approved by my previous employer,
All right.
and now I'm working with a new employer.
Okay.
The perm process is already in progress, but anyways. So my current employer, I was facing some difficulties in my current job, right? I'm on H-1B, right? And I thought, it was impacting my health. So I was thinking to, quit the job and maybe search for a new one. But again, that comes with the repercussions of being, 60 days and stuff. So I just wanted to know, so if, is my case good enough for a compelling circumstances EAD such that, I leave my job and then I have to...
See, compelling circumstance, think about the word compelling. Compelling means there is something more than ordinary, right? So, for example, if you were in counseling having psychological issues, too much pressure, or even under psychiatric counseling by having drugs and all, taking medications for anxiety, you could certainly try to make a case, and I think there is a possibility that could work. The reason I've never liked compelling circumstances EADs, we've done quite a few of them. In some cases, they are appropriate. The reason I don't like them, first of all, there's no predictability how long they'll take to process it. Then when you do get it, it's only for 1 year. Then you have to apply again next year. It goes on and on and on. So it's not the best thing in the world, but in some circumstances, it is the right thing, especially if there are health issues, family health issues, non-availability of a job. You're stuck in a situation where you're looking, you don't know when you're going to find a job, but you can get plenty of projects, short-term projects, 3 months, 6 months, 7 months. It's a good idea to go for compelling circumstances.
Yeah, I think, yes, sir. As you mentioned about, health not being good and you're looking, you're going someone. So I think that is the case.
Yeah, if you can prove that and you have the documentation to do that, definitely go for it.
Okay. Typically, how much time does that take, sir?
That I don't know, because government has been very unpredictable. It's definitely a few months. Those few months could be several months. I have no idea how much time it's taking right now.
Until my application is pending, I can still be in the US and maybe search for another job.
Yes.
And if they are able to sponsor my H1 visa, I can just transfer it maybe and drop this particular company.
Yeah, but you might have to go outside for a visa stamping, which is not the end of the world. You can just go to a neighboring country.
Okay. Sir. Yeah, and just one more question. This was from the previous question, as you mentioned, that I-140 approved going back on F1 visa. You mentioned that, it is possible that, previously you didn't know, but now, it's more common that people who have I-140 approved do get their F1 as well, right? So, over there, there is a necessity to prove to the visa officer that you will go back to your home country after you're done with your studies?
That's a pretty silly requirement, and everybody knows it. How do you prove that you're going to go back? What is the method of doing that? There is really no method. It's a matter of just being able to judge whether you are truly a good faith student or are you trying to play games with the government. So this requirement, are you going to go back, is just another way of denying. It's an excuse more than anything else.
Okay, another way. So I just don't say anything. I'm like, okay,
no, just tell the truth. That's what I tell people. Tell the simple truth. Don't try to decorate the truth.
Okay. So I think in my case, then it will be that I want to extend my work visa, so I had my I-140 approved, but now I want to go back to F1.
Yeah, well, nothing wrong with that. All right.
Okay.
Sir, you're going to have to make it. I have 3 other people waiting. So just be a little considerate.
Okay.
Yeah. All right. Good luck. Yeah. Okay. So now let's see. Area code 650 California. Let's go to 650. 650 California. I can hear you.
Hello, Rajiv ji.
Hello.
I have a very quick question, but I'll give a brief and a quick background about myself before I jump into the question.
Mm-hmm.
So basically, I have an integrated so-called a STEM degree from India in the earth sciences field. Mm-hmm. And then post that, I graduated back in 2012, and I had a 4 years experience in that specialized field itself with an oil and gas company. Mm-hmm. After that, I had to take a break because of some of my family issues. And then I resumed back my work as a data scientist and then relocated to the US after getting married. So I'm currently on H4 and I got picked in the H1B lottery this year. My company, they filed my petition and I've received an RFE from USCIS. The issue here is that the company would not release the RFE notice to me. So I'm kind of in a fix. Should I how would you recommend that I navigate this situation? The company also kind of conducted a third-party evaluation for my degree, and then the evaluator concluded that her experience kind of translates to a bachelor's degree in data science.
Yeah, that is also quite common, because with an unrelated degree, we can combine 3 years of professional experience to become equivalent to a bachelor's in that experience. Okay, so that's quite common. As far as having the company reveal the RFE is concerned, that's ridiculous. They should. I mean, you are the most concerned party in this whole thing. They should share the RFE, but can you make them do it? No.
I've been asking them to at least. The issue here is that they say there are some confidential details in the RFE. So I've asked them if they can at least highlight some major points.
What you can tell them is there's something called redacting. You know what redacting is, right? So redacting is there are redacting pens available in the market. Okay. You go to any of the bookstores or these Staples and all these books, office stores, and you ask for a redacting pen, or just go to Amazon or one of these online sites. You take a redacting pen, it's a black pen, and you black out everything that you don't want people to read.
Got it. Okay.
Tell them, can you give me a redacted copy so that at least I know that which concerns me. Okay.
Got it. Okay. And then post that, just a very small follow-up question. Once they kind of give the details of the RFE to me, would you recommend that I get a secondary opinion outside of the company's law firm on how to navigate this RFE?
Well, an opinion is only as good as its implementation. If you get an opinion, let's say you come to me and say, Rajiv, give me an opinion. I give you an opinion, but they don't use that opinion or any guidance, then you've just wasted your money. Okay. So what I would say is check with them. Just say, is it okay if I go get a second opinion? If the company would at least listen to it. Typically what we do is when people request it beforehand, we can make a recording and give it to you. So that way you can play it for your employer and say, this is what my lawyer says.
Okay. Makes a lot of sense. Thank you so much, Rajiv. We really appreciate it.
You're welcome. Good luck, ma'am. Okay, the next one is area code 470. We have just 2 more calls left. 470 is Georgia. 1 second. Georgia 470. Go ahead, please.
Hey, Rajiv, sir. Good afternoon.
Good afternoon, sir.
So this is a follow-up question based on the discussion that I had with you in our previous LinkedIn community call.
Okay.
So to give you a quick refresh, right? So I currently on my OPT, and my STEM extension gonna start in August 1st.
Okay.
And my H1 got picked up, and there's a potential layoffs in the company in the month of July.
Okay.
And my company has given me an option to choose with the processing type, consular notification or change of status. I was a little confused, and my attorney mentioned that we can transfer our H-1B approval, even though if my existing company processed my application through consular notification to a different employer. Is that true? Because I heard during stamping it's gonna get rejected because consular expect the same employer who submitted your lottery.
No.
If it
Can an H-1B be transferred if we forget all the other variables? Can an H-1B be transferred when it's consular processed? The answer is yes, absolutely. However, there is one variable which is dangerous, and that variable is if I have not received change of status and I have not received a visa stamp on my passport, transfer could be really, really difficult. Government can take the position you have not received change of status and you have not gotten your H-1B visa stamped. You have not really completed the H-1B process. You are not outside the lottery yet. If you, on the other hand, get a change of status, it improves your chances of getting a transfer because the H-1B cycle is complete. There are other issues there also. But between the two choices, if the aim is ultimately to transfer to another employer, between the choice of consular and change, I would do change of status.
Oh, I see that, sir.
Yeah.
If I go with the change of status,
that's what I think you should do. And you can feel free to, this recording will be available online, so you can feel free to play this part to your lawyers. Okay.
If we go through consular notification, and if in case if I switch to a different company, and when I go to India, and if my during my visa interview, if my H-1B gets denied, can I come back to state with my F1 visa?
You would no longer be in school, so using that F1 visa without a school admission would be illegal.
No, if I go through consular notification, I'll be on my F1 status.
So if you go through consular, you would still be on OPT, is that the plan?
Right, sir.
Yeah, the answer is yes, that is true. If you go through consular processing and you're still on OPT and you go to India, I'm assuming that's your home country, and for whatever reason your H-1B is denied, your F1 should be still valid and you can use it because you are on OPT. However, there is also a standard operating procedure which I've never seen followed, but at least it's in the books. Before they take your H-1B, they should cancel the F1. Okay. However, if they do that and then they deny your H-1B, you can still request, all right, then give me my F1 stamp again.
Got it.
Yeah. So that theoretically all of that is possible.
What do you
I would do change of status. I would do change of status.
Okay, and we can do a switch to a different company before October.
That is extremely difficult to predict which way the government is going to do it. Have we done it? Sure. But if there is no change of status, I don't remember ever being able to do it. But then again, in all fairness, I've never really done any of these cases, consular processing, because I've seen government's decisions that have talked about the H-1B cycle not being complete without either a change of status or a visa stamping. Okay?
Got it.
Good luck.
Thank you, sir.
You're welcome. Last question is back to Texas. Let's go to Texas 682. 682, I can hear you. Go ahead, please.
Yeah, hi Rajiv. I'm back again with the question.
Mm-hmm.
So I wanted to know if I travel back to India on STEM OPT, is that safe, or should I avoid traveling?
No,
back
that's
to home country
no. It's not necessarily a problem. What I want you to do is go to our website immigration.com. Okay, on immigration.com, search top right hand side, type travel. Okay. Hit enter. On the top right, you will see various content blocks in which the word travel appears. Go to my blog. It will say there are 7 entries of travel on my blog. Go to my blog, and there is a mind map of when you can travel and when you cannot travel. That's one place it is located. Another place, I think on my LinkedIn profile, it is saved as one of the pinned information pieces. So look at that. It tells you when you can travel and what documents you should carry and what you should watch out for. So travel is certainly possible. Okay?
Okay. I just wanted to make sure that there shouldn't be any, difficulty while I'm traveling on STEM OPT.
Well,
in case.
No, there isn't, because people do it all the time. While no travel is without some risk, but this does not appear to be any more risky than any other normal travel. Just to me, I don't think it makes much of a difference. If you just had 2 weeks remaining on STEM OPT, want to travel, I would have problem with that. But if you still have a few months or a year or plus pending, you'll be okay. All right?
Okay.
Good luck. Okay. I think we have
Thank
another.
you so much for the time today.
You're welcome, sir. I think we have another question come up from California. Okay. 626 California, go ahead. I can hear you.
So, quick question about the H1 to F1. You already answered about the grace period or the time gap between semester starting, college starting in September, but the grace period ending this month.
Right.
So that's fine. But let's say for some reason, if I-20 or something from the USCIS is not granted or denied in the decision is pending and it's already, my grace period is already been
No problem.
And I'm next. Okay. So what status would I be in
So
at that point?
as long as your change of status request is pending, you are considered to be in authorized period of stay, which means you are legal, even though you're not fully in status, but you're considered to be legal. Okay.
And if the F1, the I-20 was denied or something like that,
If it is denied, the day it is denied or the day after it is denied, you start accruing unlawful presence. So you should leave within 180 days, as early as you can.
And then we can file change of status at that time or no?
You can't file change of status after the denial. No, you have to leave.
So is it safe that I apply for the CPT now, and while the decision is pending, within the 60 days grace period, I could still apply for a B2 status change in the background for pending status or something?
Yeah, people do that. Maybe a little bit of an overkill. But certainly it's possible.
So if it's like a fallback if the I-120 was denied.
Yeah, but it's a dangerous fallback. Why? Because the government goes by something called the last action rule. So let's say your F1 gets approved today, and before you can withdraw it, B1, B2 gets approved tomorrow. Now you're on B1, B2, not on F1.
Oh, okay. I see.
So I'm not that crazy about that option. Okay. Good luck. All right, folks. That was it for today. I'm glad I could answer some of the questions that you folks have. I'll see you again next Thursday on LinkedIn. Everyone, take care, guys.